Hey, good evening. Welcome to Telugu NRI Radio Immigration Show every Wednesday Central 6 p.m. Central Time with Lucas Garrison from Burgos Garritson Law Firm. So this show is continuing. We are doing from past couple of months, and so we will continue to every Wednesday 6 p.m. Central Time. We would like to cover the latest updated news, and we will provide the upcoming information, and we will clear questions, and we will discuss new topics. Um, we are requesting to you all participate every week and get more information about the USA immigration system. Today we have the couple of topics. Initially we will discuss the fiscal year 2022 H1. We know that the new process will take to the wage level. We will get more information on this one, and the Biden signed a couple of executive order on immigration. We will discuss, and we'll see the what is going to be streamlined on immigration system. And also we will get the we hearing a lot of 485 rejections. We'll get more information on this one. So let's wait Lucas to the show. Hello, Lucas. Welcome to today's show. How are you?
Doing well, Venkat. Thank you for having me again. And thank you to all the viewers for tuning in this week for updated information about all immigration matters with USCIS.
Yeah. So, Lucas, we can discuss topic by topic. Let's say we will discuss the hottest topic of fiscal 2022 H1 cap. So, you can share what you have latest update from last week to today.
So, as we've discussed maybe for the past month, 6 weeks, that when President Trump was, in the final days of his presidency, he went ahead and, maybe did what we call midnight rules, where they changed the rulemaking procedures or utilized the rulemaking procedures to change some rules. Most notably, one would be the cap 2022 fiscal year cap for H-1B selection process. And as we've discussed, this is more or less the functionality of finding out what the job levels are, the SOC codes, how high the wage levels selected are, and then instead of randomly selecting the candidates to proceed with the H-1B filing, we see this new rule is allowing whoever bids the highest, so to speak, or has the highest wage offered would be selected prior to someone who had a lower wage level, like a wage level 4 would be selected over wage level 3, wage level 2, wage level 1, etc. And so, these rules were all done at last minute. This is not just the only rule that was submitted or changed, but there were quite a few. And when Joe Biden became president, on the first day, he issued a moratorium on these rules for 60 days so that the agency has the ability to review and analyze what the rules mean, how they're going to impact business, and if they're within the scope of congressional authority of what was set forth for the agencies to, work on these cases. If it's outside the scope, obviously it's something that's technically would be considered probably illegal. So the caveat with this issue is whenever there was a moratorium on these new rules, it goes for 60 days from January onward. So the issue is the moratorium is going to expire, I believe, mid-March. And the issue is March 18th. So we have to have an announcement under the new procedure that we all used last year for the registration process of at least 30 days in advance of the start date for this. Now, it's been very quiet as far as when the start date would be for this new process, for the registration process. And if it starts after the moratorium's over, and the more nothing's changed, then we're going to have to use this new rule. If the moratorium, if this process starts before the moratorium expires, then obviously we'll use the same process as last year. And moving forward, again, like what we were saying, there's key dates where we need to know by, I believe the hard date is going to be February 16th of this year to know what's going to happen for sure, so we can go ahead and start planning. So we're still a few weeks out from that date. And, is another, cause for panic or concern, the agency has gone ahead and issued, with the OMB procedure to go ahead and request the change to the I-129 form and also the registration process to include additional information. So both of these changes are currently proceeding, even if they're not going to be implemented or used. The agency is still proceeding forward with this rule as if it is going to be used. Now, at the end of the day, I firmly believe that this is something that I think is not going to impact this year's H-1B lottery, but we don't know for sure. We've been watching every day as Biden comes every day with new executive orders or new changes or proposals to immigration specifically. We're waiting to see if this is going to be included in that in one of the daily announcements. So like I said, the key date for us to watch out for is going to be February 16th. That's going to be the key date. And I know a lot of people this year, we have a lot of issues as far as like wanting to go ahead and plan and know where we're at so we can get started on the process. But it's, as usual with every year with the lottery, there's a lot of last minute details, the last minute changes. So this is all, pretty much usual business for attorneys.
Okay. Thank you. Lucas, before going to the next question or maybe next discussion, I'm requesting you all viewers and listeners, if you have any questions, you can post to Facebook or YouTube, or if you want to talk to Lucas, just dial to conference number and connect to the Lucas. The initial 15 to 20 minutes, we can discuss about the latest information. After that, I can open for the question segment that you can directly talk to Lucas and get more information about your question and the scenario. Yeah, Lucas, you are saying the very interesting point is February 16th is a main date to fiscal cap H1 2022. So you say, I hear the new word is will we have a ladder system or not? It is confirmed or it gonna get more information next couple of days?
Well, like what we were saying is the system is proceeding as if it's going to change. So the wheels, the gears that make up the agency are in motion. And there's certain protocols and things that the agency has to comply with for these new rule changes. At the end of the day, it doesn't mean these rules are going to be actually enacted or used. But at the same time, there's certain procedures. So as we can say that it's still moving forward, which is concerning for us. But, there's still option that the registration process is announced before the moratorium expires, which would mean that the changes wouldn't go into effect, or we might have an extension of some other type of moratorium to keep this from going into effect, or the newly confirmed DHS secretary could go ahead and not abide by the change in the rule, and we use the previously used system unchanged.
Okay, but if they want to implement the new system, we know last couple of years, not almost the 7 years, maybe we can think about the last year, the implementation process. So first they took only the preliminary information, your primary demographic information, and after that it got the lottery. So even till now, everyone thinking is it will it will have the same way what last year, the process. So, so if anyone want to ready to apply the CAP 2022 H1, is there any guidelines you want to say right now so that they can prepare for the apply the H1 CAP 2022?
Well, I think the best thing to do at the moment is for us to just wait until this February date, deadline comes, to pass. So anything can happen between now and that date. And I think it's best practice to probably just go ahead and wait till we get all the information, so we're not having to redo work or make mistakes and have to go back through and make sure everything's correct if something was omitted or not included that should be. And this goes hand in hand. Maybe segueing into the next topic, we're using prevailing wages to determine who's selected in the lottery. Another key announcement that came through a couple of days back is that DOL is going to reissue prevailing wages that were done under the IFR interim final rule this last October to December. Now, under that, the court has ordered DOL to go ahead and reissue the prevailing wages according to the correct prevailing wage levels that were there before the change. And some employers, if not most, have been contacted about these updates, and we'll continue seeing these come through. So if you had a case that was filed maybe during that period of October to December of last year with the higher wage level, we should have opportunity to have that corrected maybe in the next month to 6 weeks.
Okay. Even DOL will release the wage level, but the CAP H1 2022 still remain the highest wage level ladder system, right?
Correct. So the one good news is DOL did pull back the change for the increased. There was another rule for the increased wage levels again that we discussed maybe 2 weeks ago. So that has gone out. The wage levels are going to stay the same as they've been, since before October of last year. And now if the cap, the reason why I mentioned that is now that this next year, if it's used in the cap to determine what wage level you are, we know for a fact that it's going to be, what the wage levels would be. It's the regular rates. It's not the higher rates that was proposed.
Okay. So if USCIS accepting the wage level, we know that level 1, level 2, level 3, and level 4. The first who applied in level 4, they can, USCIS will accept first level 4. Let's say in level 4, apply the 85,000. It means all H1 numbers will fill into the one H4 level. What about the level 3 and level 4? Will they get a chance to get a application, lottery, get an application or not? Or how does it work for level wages system to pick up the H1 petition?
We're still going to go forward as it was done last year, where we're selecting cases based upon advanced degree, like master's quota, and then the regular selection process. Now, instead of it just being a random lottery, what we're going to have under this proposed change is going to be that whoever bids the highest is going to receive the opportunity to go ahead and file their cap case. Now we have to remember, just because you're wage level 4 in Iowa is much different than if you're wage level 4 in California. So geographically, certain areas you live in, maybe those are going to have preference over others. So I see a lot of room as far as challenges can come in and challenge the way this works. But unfortunately, due to the short nature, the timing of everything and the short notice and everything going on, I don't know how much room we have as far as like a lawsuit to suspend the unfairness or the arbitrary nature of the selection process this year. So it is kind of an unfair. It's not technically a random lottery process. It's really, you're starting at the highest wage that's going to come into the selection process through that software. And it's just going to go start at the highest wage and proceed to go down to the lower wages until all the numbers have been exhausted.
Okay. It means we can apply the same way last year. First, we will give the basic information. Once get from lottery, then we can apply the LCA. That's right.
Well, you see, so in this system, with this change, there's still we're unsure of what's going to be. So if we're going to say what the wage level is going to be, that would presumably mean that we have to file LCA. And I think the changes that were going to be made to this new system, we haven't had a chance to review it or see, but I would strongly suspect that, we're going to have to file LCAs based upon that wage level, incorporate the LCA case number to be verified through the database. And then we would have to use those same LCAs when we're filing the petitions if they're selected in the lottery.
Okay. And we can share if any updates come about H1 cap 2022 prevailing wages, lottery system highest waging level. Yeah, Lucas, we can go next topic. The Biden signed couple of execution order on immigration. Can you share is any good news for H1 holders and green card holders from these execution orders?
I think, and if I'm going to paraphrase the president, what he said yesterday is, that we're working to get back maybe respect on a global scale as far as how we treat others, specifically, how it's geared towards maybe H-1B holders or maybe people in the process filing GC. There's nothing specific yet that would impact that other than, as part of the last topic that he covered yesterday and signed in as an executive order would be reviewing the fairness of the processes we have in place. So I think, we have these 944 forms where we had to pull credit reports, assets, and all this. That's probably going to be canceled as an effect of one of these executive orders. But, as we've discussed for the past, 3 or 4 months, we have to look at things in tiers of what's appropriate. And I understand everyone is excited and wants change and wants issues to be fixed. But the biggest issue that the administration's fixing right now is trying to reunify families who were separated, where children haven't seen their parents, for maybe 6-7 months now. And the administration has to take action to maybe fix this problem. Okay, that's probably number 1 on the list. Number 2 would be fixing other issues that's impacting health and safety, families in the immigration context. And then, lastly, we would get to these inconsistencies within the employment-based immigration realm. And, that's what I've been looking for every day. And a lot of other people too, is how can we get back to normalcy? We thought maybe, there's presidential proclamation would have been lifted. It's how it affects people getting stamped. There's a lot of people still, stuck outside the United States that are in H-1B status and have been for 1 year because of this other presidential proclamation that's been extended till March. We thought he would have lifted that by now, but it hasn't happened yet. Hopefully it's going to happen, here soon, but, we'll have to wait and see how that progresses.
Okay. So the Biden almost is 12 days in administration. Do you see any streamlined processes coming up on immigration?
Yes, I do. The DHS secretary was finally confirmed yesterday or the day before, if I remember correctly, which would cover DOL. I'm sorry, not DOL. USCIS, Customs and Border Patrol, and other key agencies that involve obviously immigration. And I think now that he's officially in that position, they're going to be able to internally review a lot of procedures that are in place and kind of assess where we're at. And like I said, the proper course of action for this administration or any administration is going to be to assess, what the situation is before you make knee-jerk reactions. You never want to have a condition or something something happens where one party loses control, the other party takes over, and I just want to undo everything the other party did. Logically, we want to see what is within the scope of what the agency should be doing, and support that. And we would also want to independently review what's not working or what's not within the scope of the agency, and maybe remove those processes from there. So it's not something that can be done just overnight, but we do want to take our time and make sure we have the policies correctly reviewed.
Okay. So this is also it means whatever you explain now, it's also come under the immigration package piece by piece legislation.
Right.
Can you explain? Can you explain about immigration package piece by piece legislation?
I think this is something very keen and a positive news for all the listeners we have. Joe Biden said, President Biden said that instead of trying to put all our hopes into one package, if there's going to be obstructionists or people who are not on board with whatever the proposal is going to be, we're not going to put all the eggs in one basket. So he said he's very comfortable doing piece by piece legislation. Now, it's not the most effective or ideal way of accomplishing something, but it's better to have positive movement. This issue's been, there's many issues, we have H-1Bs on the EB backlog. That's a major issue. There's other things with childhood, deferred action for childhood arrivals, the Dreamers. And what he's saying, instead of putting everything together, maybe some of these bills will have to independently be reviewed and passed into law rather than one entire bill put together. So this bodes well, I think, for a lot of our listeners in the sense that if we have in the best light possible, hey, there's a lot of people who support the tech sector, who are contributing members to society. They entered the country with permission. They have high-skilled, high-paying jobs, and blah blah blah. That's something that maybe more Republicans might be in agreement with to fix the problem, rather than maybe not agreeing over some other issue. So there's probably better odds for positive things happening if they do a piecemeal or piece by piece legislation.
Okay. Recently, USCIS extended flexibility for responding to requests. So who will benefit from this?
Well, I mean, anyone with an application or petition or any other, request for evidence, notice of intent to deny, notice of intent to revoke, any of these cases, or anyone who has one of these issues is going to benefit. And due to COVID-19 and everything else, obviously it's been extended a few more months. It's probably going to continue to be extended at least until probably the end of summer, from what I would imagine. I can't see it really go back to the normal 60 days prior to that.
Okay. Yes, Lucas, we can go for next topic is a 485, the AOS adjustment of status in October, November. So we are seeing getting everyone, all receipts for who applied in October, but we saw a lot of rejection due to the different reasons. And here the question is, what is the possibility or chance to refile these?
Well, there's a few things pending right now. I have my notes in front of me that due to a lot of people experiencing issues with the lockbox, which is how most of these cases are submitted. With the Dallas lockbox and specifically, those standalone cases filed around October 29th and 30th. There's 415,000 applications, petitions in the processing queue waiting to be received. So there's still a lot of a backlog. The most notable issue we have is if you pay a check's really, that instrument's only valid for 90 days under, our laws under the UCC, Uniform Commercial Code. And each state pretty much, the rule is for each check, it's only 90 days. So that's 3 months. And some people, that were filed, cases filed at the end of October, we're approaching the 3-month mark, and without having anything processed, and with so many cases there, there's a lot of anticipation that there's maybe more rejections, not because of improperly filed, but because of maybe the bank notes going stale or something like this. So the American Immigration Lawyers Association's already reached out with the USCIS to make sure that any delays like this are able to be fixed. So going back to your original question, what does this mean? We think that there's probably going to be a chance to cure any rejected cases. Obviously they'd probably have to fit within a certain category of why it was rejected. But we believe that there's going to be an option, here within the next month, 6 weeks to have resolution on that.
Okay. Lucas, now we can go for question and answer. Hello, viewers and listeners. If you have any questions, you can post, or if you post in Facebook and YouTube. If you want to dial a number and if you want to connect to the attorney, just dial and ask your question and get more information. We have a couple of listeners on conference call. We will ask any question from them.
Can you hear me?
Yes.
Yes, Sri.
Hello. Sorry.
Yes, Sri.
This extension petition has been by employer B, and I have received I-7B with consulate processing such that I need to get out of the country and get stamped in Hyderabad consulate. So my question here is, my I-94 has expired on August 24, 2020. My petition has been, First thing I want to ask is, do I have to take into consideration for I-94 expiration with the stamp on the passport, or
from what you're saying, correct. Your I-94 and your stamp expired prior to your I-94 approval, the I-797A, before you received the I-797B. Is that correct?
Sorry. My I-797A has I-94 as September 3rd, 2020. But when I went out of the country and got it stamped in 2018, the passport stamp shows as August 24th, 2020.
So the most recent date of action. So what it means is, like, if your case was approved for 3 years and then you travel after you receive the approval, when you re-enter, the I-94 to be used is going to be the most recent one. So here, if you traveled and came back in, that's the new.
So I have to take
I-90.
into consideration the passport.
Correct. Now,
Thank you. So my next question is, yeah.
Go ahead. I'm sorry.
Yeah. So I have been employed with employer A until August 31st, 2020. I have my pay stub until then. But my employer B filed a transfer petition on September 3rd, 2020. And for that approval, I got the approval from January 7th, 2020, rather than all the way from September, whatever date it has been.
Right. So, most common issue is, for you to continue working and go from employer A to employer B, your transfer petition has to be filed before your I-94 expires. If you do this, you're able to continue working legally on the receipt, starting on the day the petition's mailed. So if your employer B would have filed the case on August 30th or 31st, as long as you have FedEx proof or something, it was mailed on that date and it was accepted and not rejected by USCIS for any reason, for any deficiency or anything else, you could continue working until a decision is made on the case and you would maintain status. So let's say you have a gap from August 31st until January 7th or whatever it might be for the decision, you would be considered to have been maintaining status during that period. Now, the issue with this, and that's probably why you received the 797B without the I-94, is that it won't be considered maintaining status since your I-94 expired prior to your petition being filed. So you need to be careful because the real penalties here, as far as if you accrue more than 6 months, 180 days of unlawful status, that can affect and impact, most importantly, your ability to adjust status for an employment-based petition in the future. Okay.
So my 180 days accrual will start from I-94 expiration, even though my previous employer A has filed an extension and it was in pending.
Correct. Now,
because that previous petition was filed in June itself, and when they couldn't hear anything about it, even the RSC or anything, and my employer A has terminated the job on August 31st due to COVID, and I did not have any other option rather than going with the employer B. And then within that particular 3 days gap, I have been filed a transfer petition. But my employer A's transfer petition was still in progress at that particular time. I'm sorry to ask many questions. It was like a little critical.
So
accrual days.
So you said that something was filed in June? Is that what you said?
June 2020 by my employer A, because August 2020 was my expiration. Employer A has filed extension in June 2020, but there was no RFE, no approval until August end of August. So they have decided to terminate because due to COVID situation, budget issues or something like that. So I have to get to employer B to file another transfer petition because employer A would be withdrawing it by end of August.
I see. Well, the main thing from what I understand is that there's an issue with I-94, and that's probably why you received I-797B. There's probably a decision letter denying the extension for the I-94 and explaining the reasons why. I'm not sure if your employer shared that with you or not, but that's something you need to look at. And then obviously you would want to see what's going to be best suited for you as far as like filing an MTR, as far as, what you can do to reestablish I-94 if there was some other critical error mistake by USCIS to leave you in this situation. So without more factual evidence, it'd be hard for me to go specifically into maybe remedies that you might have. But that's what you need to do is you need to probably get a copy of that decision letter and see why specifically USCIS denied the I-94.
Yeah, unfortunately, we have only received I-797B, but the separate notice determining this decision, which is mentioned in I-797B, we haven't received it. So a ticket has been raised, but I assume it might take 21 days, but I might not have that much time because
Correct.
Do we need to consider 180 days accrual from I-94 expiration or from the date the decision has been made?
Well, so if there was no decision made, did your employer receive RFE on this case?
I'm sorry.
Was there an RFE?
Only I-797B.
No RFE or anything. So you filed the case and you just received I-797B in the mail.
Oh, in between, in October they have received RFI, and that was to send the status maintenance documents, whether there were any petitions pending and all, because the previous petition was also there, such that multiple petitions have been filed. So they have, what information they have sent is previous employers' approval notice, previous employers' extension receipt notice, as well as pay stubs, as well as new employers' receipt notice when it has been filed, such as like a proof.
Correct. So what you're probably going to need is to get that decision from USCIS. Usually they send that with the original approval for the I-797B. So you just might want to, and obviously that goes to your petitioner or the attorney. So you might want to, you might check with them to make sure, but time is of the essence.
I have been checking with them, and the attorney's office have filed the ticket because they haven't received since 10 days.
Okay. Was this case filed in premium processing or regular?
It was regular. That's the reason the ticket rise would be taking more time.
Correct. Well, I wish I could tell you more information to help you, but without having that knowledge or knowing, what the reasons were for that denial of the I-94 not being transferred over, it'd be hard for me to speculate. So I think everything just is going to be dependent upon what the reasoning was.
Probably while waiting for that particular notice before deciding and going for a consulate appointment, I have to take care of the 180-day time period from August 24th and leave the country, right?
Correct. And
being
what you can do also is if there's any issue with travel or anything where you have to go back home or there's any issue with that, you can still request a deferred departure from Customs and Border Patrol. And you can do this at your airport, the international airport, wherever you're going to fly from. And what you're going to need is a ticket, an itinerary, and then some reason why, obviously COVID or something like this would be limiting your travel. A year ago, these were handed out fairly easily. Anyone who requested it would always be approved. Since we're a little bit further into the pandemic now, it's still discretional and not everyone gets the approval. So you might want to just try with that and proceed with that at your local international airport, wherever you might be. Okay.
So I will be booking a ticket and itinerary and show them such that I can stay back in the US, or I couldn't get that. So then I file a petition with Customs Border Control.
It's not filing a petition. It's basically they can give you a deferred departure if there's any emergency or something like this, as far as where it's not, where you can't travel or anything like that. But you do need to have your ticket purchase, the itinerary, and then, each airport kind of has its own rules. So I don't know where you'll be coming from, if it's Dulles, DFW, LAX, or SFO, whatever it might be. Each you just need to inquire with the CBP office at that airport. Okay.
Sure, definitely. So will filing an MTR work here, or to get the complete information, do I need to file FOIA, Freedom of Information Act, and get the complete documentation?
You won't be able to. So for a FOIA, you won't be able to get a copy of whatever was filed because you don't have any standing to receive that. Your employer would have to file that, or the attorney could file on behalf of the employer. As far as the MTR, I think clearly.
So yeah, so even FOIA will it need to be filed by my employer or attorney. I will not be eligible to file in that case. Yeah.
Correct. So the reason why, like, some people can file FOIAs for I-140s to get their record is because they're both the petitioner and the beneficiary, quote unquote, if you can think of it this way, they own the case equally. But an I-129 petition for an H-1B worker, the beneficiary has no legal standing to go ahead and request a copy, or there's no ownership, if you can imagine, for you being able to own your own case.
Why I'm asking about FOIA is, like, so if my attorney is they could not get any skeptical answer why this decision has been made by reviewing all the documents. So if I have to take any other consultation from a person like you, you obviously need all the complete packets of the documents. So
Right.
if I can file FOIA, so then I should be able to get a consultation appointment with you and get services. So that's the only concern I'm asking for. Or will you be able to, if I assign you as my lawyer, irrespective of my employer, my employer would be happy to help, but will there be any legal challenges for your law firm or you to get complete information from the attorney?
No. And the company, your employer, they own the case. It's not the attorneys that own it. So if anyone asks me, like an employer or whoever it might be, asks me for a copy of what their files are, we have to share. It's not, I'm a custodian of the files. So it's not, even though I use them and file them and, manage all this, I don't, or my office doesn't own any of these files. In fact, it's your employers or the petitioners who actually own it. So if your petitioner's not getting a copy of anything, they can obviously request that, and the lawyer has to provide a copy of that to them. But, if you need any further insight or anything, please feel free to contact me offline after the show, or, through email or whatever. I'd be more than happy to maybe help go over the next steps of what to do, and maybe try and help get a game plan together for you, because, you are.
Yeah, I really appreciate your guidance, Lucas, because I'm completely in a depressed state now because with all this timelines and all. So thank you so much for sharing the information. I will connect with you offline as well.
You're most welcome.
Yes.
You're most welcome.
Yeah. Yes, Sri, as I think you are in a complicated situation. Why don't you contact after the show? Maybe you can send an email info@bgimmlaw.com, or you can call to 214-774-4713. Lucas will respond, and you can share more information and on your case and get right direction.
Thank you so much.
Yeah. Thank you, Sri. Thank you, Sri, for call. And we have another call and conference. Srinivas, do you have any questions today?
Yes. Yeah. Hi, Lucas. Hi. Yeah.
Hi,
my
Srinivas.
question is, actually, my priority date is EB2. EB2 priority date May 17th, 2010. My daughter is already turned 21 by November 21st last year. but we filed that AOS on October 28th. Except my daughter, we got the receipts because my daughter got the F1 visa. She changed from H4 to F1.
Correct.
Before 1 week, because before turning the 21, 1 week before, even though we applied EB3 I-140, my company applied EB3 I-140 also.
Mm-hmm.
Still, we didn't get the receipt. Right now, EB3 is April 1st, 2010. My priority date is May 17th, 2010. Currently, EB3 I-140 is pending. Still, receipt is not received. Can we get something? Age out will help for my daughter?
Well, there is a law that's already here. It's called the Child Protection Status Act, and this helps protect people who might age out. Now, we would need to know more specific details, as far as like dates, filing dates, and things like that to see how it would apply. But in essence, what it means is any delay in processing or filing of the petition document, you can recoup that time and go beyond the age out date. We would need, like I said, to know more specifics because you're right on the razor's edge of something happening. So another thing that I do want to mention is, aside from the current law that we have to protect kids, that's another issue that's supposed to be addressed, with the president, because if your daughter's 21, that means she was 12 when you first filed I-140, right? And we filed before turning 21. We filed one more EB3 I-140. No, I mean, whenever your first I-140, because your priority date's 11 years ago, so she had to have been like 11 or 12 whenever exactly this happened. Exactly.
Yeah, and EB2, because even though we got the chance to, go ahead, sir.
No. And so what I'm saying is, it's not fair to have your daughter, who's pretty much grown as an American here, attended American schools, have American friends, now going to American university, to not have the same opportunity because of the delay, right? And that's something that's also being looked at right now. Unfortunately, right now, there's no law that says, anything different, but, hopefully we have two options here. Hopefully one option, Child Protection Status Act, to protect her from aging out. Now, there's a high probability that they're going to reject, USCIS will reject the application because of the age out, but this is something you really have to push, you and your attorney really have to challenge to make sure they keep it and process it. But, it's really close, and that's really, it's something really, really close. You might even also request help from a local representative for Congress to see if they can also help, once you get your receipt, maybe contact the senators in your state, whatever state you might live in, and see if they can help. And that's what I would recommend at the moment. And then also maybe stay up to date with what changes are coming, in the next few months.
Okay. But only my question is, if we file the EB2 I-485, can we file EB3 I-485 if my final action date is current? Can we file both?
So how are you downgrading I-140?
Yeah, exactly. Right now, as my situation I told you, right now my site is EB2 application, but except my daughter, I filed my 485. But now, just we filed for safe side, before her turning 21, we filed I-140, EB3 I-140, just I-140. Just we are waiting for the receipt. Once the final action date will come into picture, current, next to 47 days is there, then we are planning to file 485. Then at that time, I'm planning to include my daughter. Will it that work?
I don't know if that's really going to work. And you run the risk of maybe abandoning the current application because you're shifting and changing categories here, like a downgrade, rather than filing a fresh perm and going through that process to have an independent secondary I-140. So, if you're working with your attorney and you have a strategy there, I'm sure they have a good reason to try the strategy. And if I were in your shoes, I would also want to try every possible remedy, even if it's not 100% certain if it's going to happen. So really, whatever strategy you have with the existing attorney, if that's something that they're willing to try and you're willing to try, you can always try. But it's really it would be really a toss up on that. Okay.
Yeah. Okay. Yeah.
Your daughter.
Thanks for
another thing to remind you. Is your daughter? Is she still single? Is she married?
She is a single. She is a student. She is completing undergraduate. She is going to graduate school, medicine school.
So this is also something that can impact her if she's not included with your adjustment. Then obviously, when you have GC, you can petition for unmarried son or daughter. Now, the priority date for that's going to be, still years back, but that she could qualify under that visa category for the future. But it might keep her from being married for maybe 10 years. So that's something to consider. If things if you have to go from plan A to plan B, that's something to consider in the future. Okay.
Okay. Yeah, sure, Lucas. Thank you.
Thanks, Sri. Yeah, thank you, Sri, for calling. And if you have you have any more information, you can reach out to Lucas offline. You can send an email to info@bgimmlaw.com. Yeah. Thanks, Lucas, for 2 questions. And the listeners and viewers, still, if you have any questions, you can call to conference number, or else you can post in Facebook or YouTube. We can take your question. Yeah, Lucas, I have a bunch of questions today. We are talking about the 485 adjustment of status. Most of H1 I-140 holders are, but 485 holders are downgraded EB2 to EB3. If anyone want to do the premium process on I-140, what is the current situation?
Well, other than the extreme cost involved with it, because now premium processing is $2,500, I would really, unless your situation calls for it, I would really recommend just letting your I-140 stay and just let it be a normal process. I know we spoke last week to a gentleman who was considering the advantage of porting from employer A to employer B. Once your I-140 is approved, your employer can revoke the I-140 for up to 6 months. Also, at the end of that date of 6 months, if you have an adjustment of status application pending for that amount of time, your new employer can just file a supplement J as needed, so you can port your entire application without having to refile the labors and everything else. So if you're in a situation where that might be something considered, I would recommend, obviously it benefits you to have I-140 in your pocket. If you're in a good situation with your employer, they support you, you support them well, and you get along well, maybe there's no benefit to really spend the extra money or have the extra stress at the moment. One other thing I know that President Biden has done is they've gone ahead and looked at the filing fees. So I know under the previous administration, we all saw a huge jump in filing fees. Most notably, this last fee, the premium processing fee, went from $1,440 to $2,500. And I think, even today, we learned on a separate note from what we're discussing that, the Trump administration illegally procured, $2.5 billion from Department of Defense to build a border wall. So we don't know if he was raising fees to maybe create a way of funding this wall, or what the fees were for, why, maybe all these extra site visits and things like this going on, maybe there's a need to fund it. So I think, this is part of the new administration reviewing the current policies and see what was going on. And, maybe in the next month or two, we might see the premium rates and other filing fees adjusted to where they used to be. So it's just really up to it's based upon each person of what was going to work best for them. But if you have time to wait, I think patience is going to be key here. You can save money by not having to pay the extra fee, because the premium fee should be reset, or at least lowered closer to where it used to be.
Okay. Lucas, one question here. If it applies for downgraded I-140s who downgraded EB to EB3, if they want to upgrade to premium process, this fee amount go to the USCIS or Department of Labor?
It goes to USCIS.
Okay. I have got one alert from the USCIS, maybe DOL, whoever upgraded to premium process. This indicates that the DOL has forwarded the original I-140 approval to USCIS. It does not confirm that premium process accepted, though it make it more likely we will know when we get the premium process receipt.
So I've done this before in the past for other people outside of this scenario, where you have a separate case. Basically, as soon as you get the receipt, that's verification that USCIS has the original labor or the access to the original, and that allows you to upgrade at that time. So if you do have the receipt, that means you can go ahead and upgrade.
Okay. Lucas, I have one question on H1B. I can take one applicant. I can treat as an applicant. The applicant, the current H1 have November 2020. Before got laid off, filed for H4 in December to ensure in the status. Also, they applied the 485 since the primary applicant got adjustment of priority date in October. Recently, they had an interview and they got a job. The current company, the future company, want to apply H1. Here the scenario is the first time is they are in H1. They changes to the H4 status. The H4 status is still pending. Meanwhile, the priority date came and they apply the 485 adjustment of status. Later, they got the new job. They're ready to file the H1. In this case, can they come back to the H1 status?
Well, I think yes, to be real blunt about the answer. But to go back to maybe address an issue and make sure everyone understands, the I-140 in this situation for a derivative applicant in the adjustment of status is completely and wholly separate based upon whatever non-immigrant status they have. So the only issue that we have here for the adjustment of status would be when it comes to time when your visa is available and they're processing your application is whether or not you've maintained status. Now there's a waiver for any presence where have unlawful presence, and that is only up to 180 days. So if you have 1 month of unlawful presence, it can be forgiven through a waiver. If you think about it over the period of 10, 12 years of being in certain statuses, mistakes or things are going to happen where you might not be in status 100% of the time. Now, as far as changing status, as long as you maintain your payroll up to the time you changed from H1 to H4, and you have your receipt in hand from the H4, you can go ahead and now change back to H1. Just make sure you utilize the receipt notice that you have for H4, and you want to document that you maintain your status in H4 during this time by your spouse's H1B approval notice, by your spouse's payroll documents, et cetera, et cetera. And your attorney can help guide you through that. But just a key facet here we want to make sure we understand is that on this scenario, the two applications, the petition and application, would be independent of one another. Okay.
Okay. Yeah. Thank you, Lucas, for answer. Yep, Lucas, 7 p.m. Central Time. We came to end the show today. Thank you very much who participate today live program and the connect to the conference and call to attorney and get more information. Thank you very much, each and everyone. Thank you very much. We are requesting to you participate every week and week Wednesday and get more information on updated US immigration. And also we are requesting you share your friends and families. Maybe they might get benefited out of this live show. We are trying to help the community and we are trying to give them more the latest immigration information to you. You can educate yourself and maybe you can share to your friends and families and friends. So thank you, Lucas. Yeah, before closing, if you want to share anything else, please.
Sure. Thank you, Venkat. Again, I just want to echo what Venkat said, that this show is for the community, that Venkat and I are just a part of the show. Everyone who's participating and listening, you're the other part of our show, and we appreciate the input and the questions raised and the participation. And again, we're here to serve the community. And if there's something that we didn't address or didn't have time to address, please approach us through our email or phone directly, and we'll try and help you as best we can. And again, a lot of these changes are going to come quick and unannounced, as far as some of these changes in regards to the H-1B cap or current H-1B standards, or maybe even GC processing or things like this. So please stay tuned. Venkat and I will try and update everyone. If anything major happens, we'll go live on the same day it happens. And just keep all your friends informed, and please share the link and follow us on our Facebook pages and YouTube. And we're here again to help support the community. So the more viewers we have, the more people we can help.
Yeah, thank you very much. So if anyone want to connect offline, you can send an email to info@bgimmlaw, and you can send a question and you can get clarified via email, or else you can call to 214-7744-713. Thank you, Lucas, today having show. Bye-bye until next Wednesday. See you on next Wednesday at the same time, the same platform. Thank you. Good night.